This hearing is called to order. Good morning. Welcome to the witnesses. Welcome to everyone who's come to attend. The Internet is one of the most revolutionary forces ever unleashed on the world. This transformational technology has changed how we learn, how we communicate, how we do commerce, how we live our lives. People even meet and get married through the Internet. And of course, the Internet didn't invent itself. It wasn't invented by any politicians. It was invented by the incredible ingenuity of the American people with the financial support of American taxpayers. In the spirit of freedom and generosity that is the essence of our great nation, the American people didn't try to keep the Internet just for themselves, but made it available for the benefit of all humanity. Since the Internet's inception, the United States government has stood guard over critical Internet functions. In almost any other country, that power could have been used to deny Internet access to websites that were deemed politically undesirable or unpopular or threatening or simply disfavored by the powers that be. But not here. Not in the United States. Because of the First Amendment to our Constitution, which affords more protection for speech than anywhere else in the world, the United States government, as long as it has authority to oversee the infrastructure of the Internet, has a duty to ensure that no website is denied Internet access on account of the ideas it espouses. Under the guardianship of the United States and the First Amendment, the Internet has become truly an oasis of freedom. But that could soon change. In 16 days, without seeking the consent of the American people, without seeking the consent of Congress, the Obama administration has stated that it intends to relinquish the government's historic guardianship and give it instead to an international body known as ICANN. Now, what is ICANN? It is not a democratic body. It is a corporation with Byzantine governing structure designed to blur the lines of accountability that is run by global bureaucrats who are supposedly accountable to the technocrats, to multinational corporations, to governments, including some of the most oppressive regimes in the world, like China, Iran, and Russia. Sadly, ICANN officials have already begun showing extraordinary affinity for China, the world's worst abuser of Internet freedom, according to Freedom House in 2015. Numerous ICANN gatherings have featured Chinese officials responsible for Chinese government censorship and propaganda. ICANN's recently departed president and CEO, Fadi Shahadi, who shepherded the transition plan through the Obama administration, made China a central focus within ICANN and the future of that organization. Mr. Shahadi is on record saying that, quote, from ICANN's standpoint, engagement with China is not an option. If we do not engage with China at every level of our community, we frankly lose a part of our global legitimacy. It is striking that an organization we are being told we should trust with control of the Internet believes that legitimacy depends upon engaging in a regime that is the world's leading censor on the Internet, silencing speech on the Internet, and that imprisons democracy and human rights and advocate and Nobel laureate Liu Xiaobo. Not surprisingly, Mr. Shahadi left ICANN after the transition plan was approved to lead a high-level working group for, wait for it, China's World Internet Conference. A conference that was rightly criticized for refusing to let New York Times and Washington Post reporters cover it. As a result, Reporters Without Borders demanded a boycott, calling China an enemy of the Internet. And yet we are being asked to trust an organization without having our government have the authority to protect free speech, to trust an organization whose former leader who shepherded this plan has gone to associate himself with and stand with those who are, in the words of Reporters Without Borders, the enemy of the Internet. Once the government's out of the picture, First Amendment protections go away. The First Amendment, by its term, binds the government. It doesn't bind private individuals. That means when ICANN escapes from government authority, ICANN escapes from having to worry about the First Amendment, having to worry about protecting your rights or my rights. Imagine an internet run like one of our large private universities today, with speech codes and safe zones. An internet that determines some terms are too scary, microaggressions are too troubling, we will not allow them to be spoken on the internet. Imagine an internet run like far too many European countries that punish so-called hate speech, a notoriously malleable concept that has often been used to suppress views disfavored by those in power. Or imagine an internet run by, like many Middle Eastern countries, that punish what they deem to be blasphemy. Or imagine an internet run like China or Russia that punish and incarcerate those who engage in political dissent. Now, some will say none of that parade of horribles will happen. There's nothing to fear here in handing control of the internet to this international group of stakeholders, this mini-UN. Well, that's what this hearing is here to determine. Is there something to fear? And I will point out a question I think a lot of Americans are asking is why risk it? The internet right now works. It's not broken. What is the problem that is trying to be solved here? That's what this hearing is about as well. Chairman of the full committee has asked to give an opening statement as well. Senator Grassley.
The openness, security, and stability of the internet are principal importance to all of us who use the internet around the world, and yet it is the United States historic stewardship and its role over key internet management functions that helps to ensure this openness, security, and stability. Today, this administration intends to end this role not for technical considerations, but for political reasons. This is happening despite the fact that the number of significant questions related to transition remain unanswered, including whether the transition will yield an unconstitutional transfer of United States government property, how the transfer will affect human rights and free speech issues if U.S.-controlled top-level domains such as .gov and .mil could be compromised, or if the Internet Corporation for assigned names and numbers will be subject to increased antitrust scrutiny. Here at the committee, we've continued to engage with the administration about this transition, and to date, answers we've received have been very inadequate. It's clear that the administration hasn't conducted a thorough legal analysis of many issues outstanding. In ICANN, we see an organization that was blasted just this past July by an independent review panel for its inability to carry out basic duties of self-governance. The review panel found that ICANN Board Governance Committee has, quote, failed several transparency obligations, engaged in cavalier treatment of constituent requests, and failed to undertake an examination of whether ICANN staff or contractors complied with their obligations under the articles and the bylaws of incorporation. These failures then raise serious concerns about the ability of ICANN to exercise proper corporate oversight and call into question ICANN's organizational maturity. These types of governance problems make ICANN susceptible to corruption and abuse, and call for the extension of ICANN's contract and the United States' continued oversight and involvements. Such concerns, especially when it comes to accountability and transparency, are reasons why I have always questioned if the transfer is in the best interest of the American people and global internet users. Despite the administration's intention to give up IANA functions contract, these concerns still persist, indicating that this course is misguided and at best prematured. So I appreciate, Senator Cruz, your taking the leadership during this hearing and look forward to what the witnesses have to testify about.
Mr. Marby.
Mr. Chairman, ranking members and members of the committee, thank you for inviting me here. I'm honored to discuss those important issues, and I welcome this opportunity to answer your questions. The IANA stewardship transition marks the next step in the evolution of how Internet's addressing system is coordinated. The transition was first envisioned in 1998 when ICANN was formed and was supported by Democratic and Republican administrations since. If I will leave you with one point today, is this: no one controls the Internet. You can think about it as a machine with many moving parts, with ICANN being just one part of that machine. And ICANN can be replaced in that machine. The IANA function has nothing to do with content or freedom of expression. ICANN have nothing to do with protecting free speech on the Internet. We do not and cannot impact how sovereign states censor speech within their borders. The Internet, with its many moving technical parts, is currently running smoothly. It's a voluntary arrangement among private actors operating on the basis of trust. ICANN's primary job is to coordinate the top level of the Internet's naming and numbering systems. Essentially, we publish a telephone book for the Internet. The IANA functions are a technical feature that helps the Internet operate like a single global network. ICANN plays a small but significant role working together with other organizations such as the Internet Engineering Task Force, the regional Internet registries, Internet service providers, and many more to make the Internet work. It is important to note that ICANN is not a regulator. The only power we have is through more than 2,000 contracts and agreements with registers, registrars, and other entities across our multi-stakeholder community. Because ICANN is a California public benefit non-profit organization headquartered in Los Angeles, and these agreements are subject to California law. Our bylaws and articles of incorporation firmly subject ICANN to US jurisdiction. And let me add that ICANN is not now, nor it ever been, exempted from antitrust laws. When ICANN's contract with the US government expires, nothing will change for the world's 3.4 billion Internet users. The ending of this contract will not increase the role of governments over the Internet or ICANN as an organization. In fact, there will be a stricter requirement that is currently in place for consolidation of government advice. Governments that do not support a free and open Internet do not support the transition. They hope it will fail or will be delayed. The proposals submitted to the US government were developed by US industry, global businesses, technical experts, civil society, and academia. Stakeholders engaged in more than 2 years of discussion, debates, and compromises. They devoted thousands of hours to work to ensure that the views of Congress, the Department of Commerce, the private sector, and global stakeholders were all taken into account. The proposals build in additional checks and balances to hold ICANN organization and the board accountable after the transition. This is why the transition is widely supported by the US business community, US human rights organizations, and global Internet stakeholders. The US Chamber of Commerce, Microsoft, Amazon, Dell, the Internet Association, Human Rights Watch, Freedom House, and numerous others have voiced support for the proposals submitted to the US government. The global Internet community, including all these US companies, organizations, and users, has called for the transition. The ICANN organization is ready, and we believe the transition should proceed on plan without delay. Thank you, and I'm looking forward to your questions.
Thank you, gentlemen. Mr. Strickling. You said you were here to testify in support of freedom. And you said freedom, quote, depends on the network of stakeholders. Now, you and I are both graduates of the Harvard Law School. Somehow, we have survived that.
You better than me, it appears.
The First Amendment, by its terms, applies only to state action, to government action. It binds the federal government, it binds the states, it binds local governments, American governments. The First Amendment does not bind foreign governments. The First Amendment does not bind private corporations. Would you agree with everything I've just said?
Yes, sir.
So, your testimony to this committee is that we should trust these stakeholders, none of whom are bound by the First Amendment, with protecting our rights. And indeed, you cited a number of the global technology companies. In your judgment, do the global technology companies have a strong and impeccable record of protecting free speech online?
Sir, I would like to make two comments in response to that. First off, in your opening remarks, you posited a vision or a scenario of ICANN and the U.S. government's role in it vis-a-vis the First Amendment that just does not comport with the facts.
Sir, I asked you just a simple question. Do the global technology companies have a good record of protecting free speech online?
I would believe that they do a fine job of that, but I'm in no way position of saying that they've done a perfect job of that. But the comparison here that's important is how will it be different between the existing situation at ICANN and what will be in the future. When you talk about the First Amendment protecting content online, you're talking about website providers who are operating at the second level, third level of the domain name system. NTIA in the Department of Commerce and the U.S. government has no role whatsoever with respect to who gets domain names at the second level or above, what content they put on those websites, and how it is handled internationally. So when you posit that there's some First Amendment protection that exists today, I'm not sure what you're talking about, because when you're talking about website owners, we're not involved in that. So there will be no First Amendment protection from the United States that would extend in any way to protect people operating at that level of the domain name system.
I will say it is remarkable and distressing to see a senior representative of the Obama administration saying you have no idea what I'm talking about when it comes to First Amendment protections. Because I'll tell you exactly what I'm talking about, sir. Right now, under the existing arrangement, if ICANN decided to delist a website because it disagreed with the political content, I'm assuming your agency would step in to prevent that.
That's not, you're not positing a realistic scenario. ICANN would be involved
You're
at
saying
the
they
domain,
wouldn't do
at
that.
the,
I'm
at the
asking how
top
you
level
would...
domain level. We're talking .com, .net, .web, those sorts of names. We're talking about the names that then other people in the internet ecosystem would then use to develop their own websites. So ICANN would never be involved in the takedown of a second level, third level site, except to the extent that it's involved as part of their contract compliance issues with registrars. But the United States has no role at that point.
You just said they wouldn't do that, except if they did it as part of their contract compliance. But this is all under the context in which they are operating under a contract with the United States government.
It is not. It is not, Senator. That's not correct.
Sir, please do not interrupt me.
I apologize, and I will listen to your question.
In a circumstance where the United States government relinquishes any oversight over this contract, the oversight instead shifts to multinational stakeholders. Now, you testified in response to the question I asked you earlier that you think that the global technology companies have, I think the word you used was a fine record protecting free speech. I will tell you, I for one am not comforted with trusting our freedom to companies with a, quote, fine record, although you said not perfect. And I suspect there's a reason you said not perfect. Because, for example, Microsoft, Facebook, and YouTube, which is owned by Google, all of whom are supporting this transition, signed a code of conduct with the European Union to remove so-called hate speech from European countries in less than 24 hours. That is not what I would call a fine record of protecting free speech, working with governments to take down speech that they disagree with. Likewise, Facebook recently faced serious allegations of censoring speech on its platform to silence conservative voices. And I would note this is not uniform one direction or another. Progressives, leftists, Verizon refused to distribute an optional opt-in text message from NAR Pro-Choice America, saying that it does not accept programs from any group, quote, that seeks to promote an agenda or distribute content that, in its discretion, may be seen as controversial or unsavory to any of our users. Now that, I would suggest, is not a fine record of protecting the First Amendment. Now listen, Verizon, Google, Facebook, they're not government entities. They're not bound by the First Amendment. But the United States government is. And for those of us that want the internet to remain free, want to avoid internet censoring, being told that we should trust these stakeholders when their conduct over and over again, indeed, recently, the Journal of Law, Technology, and Policy at the University of Illinois said, quote, prominent American corporations, including Cisco Systems, Microsoft, Nortel Networks, WebSense, and Sun Microsystems, have all played a part in quickly equipping China with censorship equipment. You are asking the American people to trust private companies with control over their free speech and remove the U.S. government role.
I am not, Senator. That is absolutely not correct.
What is incorrect about it?
The United States involvement is only with respect to the IANA functions. That is what we contract with ICANN to perform. That deals at the highest level with the root zone file, meaning top-level domains. It has nothing to do with what choices individual companies make in terms of what they put on their own websites. It has nothing to do with what is happening with the content of what's passing on the internet day by day. We have no role in that. We have no authority over that. All we're suggesting is that that contract in which all we do is verify that changes to the root zone file have been made accurately no longer has a technical reason to exist and no longer has a political reason to exist, because if anything, it's being used by authoritarian governments who do want to control content, who do want to affect what goes over the internet. It gives them the opportunity to argue for that in international venues and attempt to wrest control of the internet away from the multi-stakeholder body that performs these functions today.
You testified before this committee that the American government would remain, I think the term you used was a, quote, forceful advocate.
Yes, sir.
For free speech.
Yes, sir.
That is very much the same language that is used on the NTIA's Q&A document that says the United States, quote, will continue to play an active leadership role in advocating for a free and open internet within ICANN as a member of the Governmental Advisory Committee and in other international venues.
That's correct.
With all due respect, simply being told that we will argue for the First Amendment and try to convince Russia, try to convince China, try to convince Iran the First Amendment's a good idea, within the Governmental Advisory Committee, if this transition goes forward, would the United States government have any greater ability to defend its position than would Russia or China or Iran?
The important point to take away from the Government Advisory Committee is that for it to render advice that has any force with the board, it has to be consensus advice, meaning it has to be advice to which no government objects, which means there will be no advice coming out of the Governmental Advisory Committee that the United States doesn't agree to that requires the board to take any particular action with respect to it. Otherwise, the board can continue to reject GAC advice as they do today.
Just to clarify your answer to the question, if the transition goes forward on the Governmental Advisory Committee, the United States would be on the very same footing as would Russia or Iran or China.
That's correct. But what I'm telling you is that nothing will go forward from the GAC that the United States doesn't agree with.
Very good. We'll continue this questioning. Chairman Grassley.
Mr. Strickland, I happen to agree on the importance of continued U.S. control of top domain names such as .mil or .gov. In 2015, you testified that you would, quote, take a look and make sure that if there is a way we can strengthen the U.S. government's rights to those names, we will do it, end of quote. And while NTIA and ICANN affirmed that, quote, any change made to .milcon or .gov can only be made with the express approval of the U.S. government, end of quote, we've come to learn that the affirmation has come not through a binding legal agreement, but by a mere exchange of letters, and it remains possible that ICANN could redelegate these. Why is the administration content to receive so little assurance, a mere letter, instead of a binding legal agreement from ICANN? And follow-up question, has the NTIA consulted with the Justice Department, a member of the DNS Interagency Working Group, regarding this language? And if so, what was their response?
So your answer to your first question is the United States does not wish to cede any sovereignty that we may have over .mil and .gov, and that is why we have done this as an exchange of letters. The United States, prior to the creation of ICANN, had the complete authority and control over .mil and .gov. That condition exists today, and it will continue on in the future. To enter into a contract with ICANN would, in some respects, risk indicating that ICANN has rights in the control or authority over those names that it does not have today. And so in evaluating the desirability of doing a contract, it became clear, understanding the history of these domain names, that that actually was a risky maneuver and might lead to the United States ceding some form of authority over these names that we enjoy today.
What about consulting with the Justice Department?
Well, we consulted with the Department of Defense because it operates .mil. I don't recall whether there was a specific discussion with the Department of Justice about it, but this was the course of action that the operator of .mil wished to take in terms of doing this as an exchange of letters as opposed to doing a contract.
Mr. Marby, is ICANN opposed to executing a binding legal agreement with the administration that would ensure that the U.S. continue to control certain top-level domains like the ones I mentioned permanently into the future?
I think it's up to the U.S. government to decide how it likes to have the protection. I will emphasize we don't see that we have any rights over that today. And I also would like to restate the fact that if the transition doesn't go through and ICANN is replaced with something else, which we can be technically, there will be no safe haven for those names.
Let me ask you, Mr. Marby, something that Senator Cruz has touched on. In your testimony, you explained that ICANN, place of incorporation, isn't a settled matter, and that it and the location of ICANN's headquarters could potentially change. Your predecessor went so far as to announce in 2014 that ICANN board had, quote, given him the green light to begin working on the creation of a parallel legal international structure member in Switzerland for ICANN, end of quote. No matter how much the administration and ICANN wish to downplay this issue, it's one that many people are rightly concerned about, and it's an issue that hasn't truly been settled. So, is ICANN opposed to including requirements in ICANN's bylaws to definitively ensure that ICANN's place of incorporation never changes from California, or is it impossible and a reason why this transition shouldn't go forward?
I think we fairly say that the protection is stronger than just its bylaws. The whole concept of ICANN is built around Californian law. That's the charter of how we do things. So to be able to do, you have to go all the way down to how we are organized to be able to do that. So it's a stronger protection than just the bylaws.
Mr. Chairman, I'm done.
Mr. Marby, let's.
Could I have 15 seconds, please?
Sure.
Because I thought that Mr. Marby answered my question, and then Senator Lee followed up. I'd like to know from you, for clarification, whether or not it is in the bylaws is there no way that you can sit here and definitively assure me that ICANN's place of incorporation will never change?
First of all, let me explain a little bit about my role. I'm the CEO and president of the ICANN organization, which is a supporting organization to the community and the board. Any decision that is made, it has to be made by the community and not by me. That's the way that this is set up. I'm here to execute the wishes of the community.
Okay, so you can't assure us then that it's always going to be under California law in California?
To be able to change where we are, because of the fact that we built upon California law, we have the charters and the bylaws are built upon California law. I would say it will be a very hard thing to do. I think it would be easier to start a new ICANN elsewhere with no California law as a basis.
Thank you, Mr. Chairman. Let's, Mr. Marby, stay focused on this question. You've made a lot of references to the bylaws. As a nonprofit, and indeed Mr. Strickling also told us we should trust the bylaws because they ensured that nothing can go out of the Government Advisory Committee without consensus. Under California law, does anything prevent ICANN from changing its bylaws at any time it wishes?
There are checks and balances built in to the system to be able to change those bylaws.
So yes, ICANN can change the bylaws. If we sit here today and say there's something in the bylaws, after the transition, ICANN could change the bylaws and remove whatever the assurance is we're being told to trust.
If you refer to as the ICANN organization, the answer is no.
ICANN cannot change its own bylaws?
As I said in my open statement and many times said before, to be able to make sure that nobody takes control of the ICANN, which consists of three parts, the community, the board, and the organization I represent, which is a support organization. I, as the CEO and president of the ICANN organization, don't have the mandate, don't have the possibility to go in and change or propose bylaw changes. The only ones who can do that is the community, which are consisting of, for instance, U.S. businesses.
So, just to clarify, your testimony is the community, the U.S. businesses who have had a questionable record of protecting free speech in the past, have the authority to change the bylaws in the future. Is that correct?
As I stated earlier, if someone really wants to change this setting, it's easier to start an alternative ICANN with another root system outside the US.
I'm not asking which is easier. I'm asking if the bylaws can be changed.
There are so many checks and balances within the system. I would say it's hardly possible to do.
Sir, this isn't a complicated question. Can the bylaws be changed? You're saying, gosh, it'd be easier to do something else. That either the bylaws can be changed or they can't.
I think I answered the question to the best of my ability. I cannot do it. The community, after all, checks and balances, but the whole bylaws are built on California law.
And under California law, the bylaws can be changed by what you referred to as the stakeholders community, correct?
After, there are checks and balances built into that system to all represent U.S. users and other ones into that system as well. It's not only U.S. companies that are in there as well, and therefore that's why the transition has so much support from other parts as well.
Now, to follow up also on your exchange with Chairman Grassley, can you tell this committee today that there is zero possibility that ICANN will choose to move abroad to a foreign jurisdiction?
I don't have the mandate to take that decision, as I explained earlier, and we have no intention of moving ICANN.
But you cannot say there is zero possibility it will occur.
I'm only representing the organization. I would say it's highly improbable to do that.
Well, then let me ask you, your predecessor, Mr. Fadi Shahadi, on February 21st, 2014, before the French Senate said, quote, "First, to begin working on the creation of a parallel legal international structure, maybe in Switzerland, for ICANN." Why was he telling the French Senate something different from what you're telling the American Senate?
First of all, I cannot read it because it's too low. And I cannot explain that because I don't know which circumstances he said that.
So you have no explanation for your predecessor making reference to creating an international organization in Switzerland for ICANN?
Neither him or me has that mandate. And if you look back to in the bylaws and how we set it up, also that the US government is satisfied with the protection we built in.
All right, well, talking about your predecessor, let's talk about another aspect of his record, which is that he stated, if we do not engage with China at every level of our community, we frankly lose a part of our global legitimacy. And indeed, after leaving ICANN, Dr. Chahadi became co-chair of an advisory committee to the World Internet Conference organized by China. He did so after Reporters Without Borders called for a boycott on that conference, saying that China was an enemy of the Internet. Now, do you agree with Mr. Chahadi's views of China?
Maybe this is my English. I don't really understand the question.
Do you agree with Mr. Chahadi's views about China, about the legitimacy of China, about the need to work with them, even when they are censoring the Internet?
My understanding is that there are about 300 million Internet users in China. We are a non-political technical community that works to be able to make sure that the Internet functions technically. I cannot vouch for what my predecessors said in different surroundings.
Well, let me ask you this. Do you agree with what Reporters Without Borders said in December of 2015, that China is, quote, the world's leading enemy of the Internet? Do you agree with that?
You're asking a personal questions, which I will now ask in a personal way, if I may. The reason I'm working for ICANN, the reason I took this job, the reason I left private sector, is because I think Internet is a vehicle, as you believe, Senator, to be able to open up hearts and minds of people around the world. I don't even go close to what you do when it comes to policies, what happens on top of the Internet. ICANN cannot prevent anyone, any country, any network owner to prohibit their users to be able to prohibit access to information on the Internet. What we do is to create the opportunity for networks of networks, for other ones to use or not to use. It's a voluntary system.
Sir, so let me just ask this question again, because you did not answer it. Do you agree with Reporters Without Borders that China is the world's leading enemy of the Internet?
I think there are many countries around the world who unfortunately prohibit access to information. I think it's bad every time.
Do you think China is an enemy of the Internet?
I don't have the competence to rank those.
I didn't say rank. I said, do you agree that China is an enemy of the Internet?
I think there is a highly potential risk if the transition doesn't go through, that China, together with Russia and other countries, will use that possibility to move the supervision of ICANN over to the UN.
Is ICANN bound by the First Amendment?
I think you know the answer to that question. And
I'm asking your views.
To my understanding, no.
I want to finally make a point that the criticism, the opposition to transferring control of the Internet to an international community of stakeholders without any authority of the U.S. government is bipartisan criticism. It is across the spectrum, because freedom, ensuring the Internet free of censorship, is and should be a bipartisan objective. I would note that former Obama administration Federal Trade Commission Chairman John Leibovitz has stated that it, quote, it was difficult for the Commission to get straight answers out of ICANN, and, quote, that if commerce cuts the umbilical cord with ICANN before these issues are ironed out, there will be a lot of risk to consumers. That's the chairman of the Federal Trade Commission appointed by President Obama. Likewise, Delaware Secretary of State Jeffrey Bullock, from the home state of the ranking member on this committee, expressed his views of ICANN in an August 2016 letter in which he wrote that, quote, legitimate policy concerns have been systematically brushed to the curb by ICANN staffers well skilled at manufacturing bureaucratic processes to disguise predetermined decisions. And likewise, I want to point to yet another famous right-wing organization, the Washington Post, The Washington Post editorial board said, quote, "It's bad enough that these authoritarian governments repress online expression within their borders. They should not be let anywhere near the governance of the Internet's global infrastructure." No one has yet had a convincing explanation for how the multi-stakeholder model will be immune to pernicious influences from governments. This criticism is widespread, it is bipartisan, and it is unified behind the need to preserve freedom online. Senator Flake.
Thank you, Mr. Chairman. Thanks for holding the hearing, and thank you for testimony. And I apologize, I have to run very quickly, but I wanted to just ask one question with regard to the second panel that will be coming up. We'll be hearing from the ordeal of an Arizona corporation, Ping, trying to register a top-level domain. They tried to register the Ping domain name and wound up paying over $1 million to do that at auction. I think it's troubling that Ping was essentially forced to pay for its own intellectual property. How will the ICANN transition address concerns of American trademark holders like Ping, and will the process of resolving these kind of claims change following the transition?
Let me start in terms of the impact by the transition itself. What you're describing is the process established by the community as to how it would expand the list of top-level domains that are available. And as a result of this, hundreds of new domains have gone into the root file. It has nothing to do with the performance of the IANA functions. So the contract that we have with ICANN, under which they perform updates to the root zone files, does not reach this policy-making activity of ICANN. And so when the contract goes away, it will still be up to the community of businesses and everyone to set the policies. Now, the example you're talking about comes right out of the guidebook that the community developed over years in terms of what to do when multiple parties seek the same domain name, because it's not like the trademark world where people can, like Apple, can use Apple as a trademark in one context, and a different company could use Apple in a totally different industry. Unfortunately, on the internet, only one person can have .apple. And so the question the community faced was, how do we deal with the competing claims on these names? And what the community decided, and by the community, I mean all of the businesses that are now seeking domain names, along with the technical experts and civil society members that participate in this policy-making process, decided that where you have two people making equal claims for a name, they need to work it out. And at the end of the day, the process that they put in place to resolve at the end is an auction, which can be conducted privately or can be conducted under the auspices of ICANN. The parties decide that, and that's been used. Has it been a great outcome? It's a good question to ask the second panel if they feel that the experience of dealing with these contention sets where people ask for the same domain name has worked out the way they expected it to when they set that policy several years ago. As they look forward to establishing a second round of expansion of domain names, the community may well choose a different way to handle that. But the point to keep in mind is that's part of ICANN policy making. That's part of what the multi-stakeholder community does. It is not in any way within the scope of the IANA functions contract that we have with ICANN.
Thank you, and I'll submit additional questions for the record. Thank you, Mr. Chairman.
Thank you, Senator Flake. This will be the final round of questions for the first panel. Mr. Strickling, I want to focus right now on questions of compliance with federal law. If Congress passes an appropriation rider this month mandating that NTIA renew the contract with ICANN, will you commit that NTIA will comply with that mandate?
We will follow your direction, sir.
So you are aware, and that means you will renew the contract if that's mandated.
If that's what we are told to do and that passes Congress, we will do that. And we have taken the preparatory steps to allow us to do that as late as the night of September 30th, if it comes to that.
Now, you are aware that Section 539A of the Consolidated Appropriation Act already makes clear that, quote, none of the funds made available by this act may be used to relinquish the responsibility of the National Telecommunications and Information Administration during fiscal year 2016 with respect to Internet domain name functions, including responsibility with respect to the authoritative root zone file and the Internet assigned numbers authority functions. That is existing federal law.
That's correct.
Passed by Congress and signed by the President.
That's correct. And I have followed that as well as all members of my staff.
So it is your testimony you have followed this?
Absolutely.
That you have, and you're aware that when an appropriation rider says none of the funds may be spent carrying out a function, that means not only dollars, that means time of government employees.
Right. I have done nothing to relinquish the responsibility of NTIA with respect to the Internet domain name system during this fiscal year.
So it's my understanding that the NTIA awarded a contract in the amount of $18,690 to the Berkman Center at Harvard University to study the transition plan. Is that correct?
We asked for corporate governance expertise. That's correct.
It's my understanding that the NTIA paid Professor Brackman Reiser $9,207 to conduct a review of the transition plan.
That sounds correct, yes. We absolutely retained her.
It is my understanding that the NTIA incurred expenses of $1,658 for 2 meetings in New York with experts relating solely to the transition. Is that correct?
We had 2 meetings in New York. I don't remember the precise dollar amount, but that sounds right.
And you have used government salaried staff time to conduct a review of the transition and to prepare and draft the IANA Stewardship Transition Proposal Assessment Report. Is that correct?
Just as Congress directed us to, yes, sir.
You're also aware of the terms of the Federal Anti-Deficiency Act, also federal law, which provides that it is a criminal offense punishable by up to 2 years in prison and a $5,000 fine if an officer of the government knowingly and willfully makes or authorizes an expenditure or an obligation exceeding an amount available in an appropriation or fund for the expenditure of the obligation. Are you aware of that?
I'm aware of the Anti-Deficiency Act, yes, sir.
How would you explain to this committee, does your conduct, the expenditures we went through, all working to relinquish the control of the Internet? How is that consistent with federal law and the Anti-Deficiency Act?
Well, you've just added a word that's not in the rider. You added working to relinquish responsibility. I have not relinquished any responsibility. But the provision does not reach preparatory activities, and indeed Congress expected us to engage in preparatory activities because at the time the first rider was passed in 2014, we were directed to conduct a thorough review of any transition plan that we received. So Congress understood that during the pendency of that rider that we would be engaged in activities preparing for the transition, but those themselves do not relinquish any responsibility.
Do you have an Office of Legal Counsel
I do.
opinion stating that, as you put it, preparatory functions are not included in this rider?
We were so advised.
Do you have a written opinion from OLC to that effect?
I have it from my Office of General Counsel at the Department of Commerce.
I would ask you to submit that legal advice to this committee.
I understand. I will take that back.
But you do not have an opinion from the Office of Legal Counsel of the United States Department of Justice to that effect?
I'm not aware of one, no.
I would point out that under your interpretation, which I consider to be tortured interpretation of this statutory language and unfaithful to the text, and let's go to the other one, to the actual rider. Your interpretation is preparatory conduct is not encompassed in this, so that the Commerce Department can do absolutely everything required to relinquish the Internet, the responsibility, right up until the moment of pushing the button.
Well, sir,
I'm sorry. Your position is every single act of preparation can be done, and as long as it actually hasn't been culminated with the relinquishment, that is perfectly okay. I'm going to say two things. Number one, I'm going to ask you, if that interpretation is right, why on earth would Congress pass this? This is a meaningless rider. If your interpretation is right, what the heck is Congress prohibiting?
They have prohibited us from relinquishing responsibility. But let me ask you this, Senator. What is the responsibility you referred to there? The only responsibility that we have is not based on any statutory obligation.
Mr. Strickling, I understand.
Let me finish, Senator, if I may.
Understand.
Senator, if I may finish.
No, you may not. You may answer my questions.
I'm telling you that the responsibility we have has been to privatize the domain name system.
I understand that you have a political mandate to do that.
But
let me be very clear. The fact that you disagree with the policy judgment of the Congress of the United States as reflected by federal law, you're entitled to disagree with it. Here's what you're not entitled to do, sir. And I want to speak for a moment to the employees who work for you, to the government employees at the NTIA and at the Department of Commerce. These legal prohibitions have been passed into law by Congress and signed by the President. If your political superiors instruct you to proceed with this transition, to spend your time, to spend 1 penny of government money, you have an obligation as an employee of the federal government to decline to follow that instruction, to violate federal law. And let me note for you, if you don't, if your superiors direct you to do it and you carry out those orders under the Anti-Deficiency Act, you are risking personal criminal liability of up to 2 years in prison. And I would note, this administration that has politically mandated handing over oversight of the internet, this administration is not going to prosecute anyone. But in January of 2017, a new administration will be in Washington. We don't know who that will be, but I am advising the employees of the Department of Commerce, your political superiors do not have the authority to instruct you to violate federal law, to violate what Congress has passed. Mr. Strickling has told us he disagrees with Congress. He's entitled to disagree with Congress. He is not entitled to instruct federal employees to violate federal law. And each of you should be on notice who has worked hard to have long, distinguished careers that political appointees of this administration cannot instruct you to violate federal law.
Senator, we have followed the law. We have not relinquished our responsibility. I am outraged that you are accusing us of doing that, especially when the very conduct that you raised, if I may read to you, the committee directs NTIA to conduct a thorough review and analysis of any proposed transition of the IANA contract. We were directed to do that as part of the spending bill that was passed for fiscal year 2015. It carried forward in fiscal year 2016. So it's clear that Congress never intended to relinquish the responsibility to mean all of the preparatory activities we are engaged in, because we were directed specifically to conduct a review of the plan.
Mr. Strickling, a committee report cannot change clear statutory text. And you, under your interpretation, which I consider not a reasonable interpretation of federal law, because it renders federal law absurd and meaningless. Under your interpretation, this rider had no effect whatsoever. And for those federal employees working for you, they need to make a determination. Are they willing to risk their own careers based on what I believe to be a political interpretation? I hope the answer to that is no. Congress has the authority to make this determination, and you are welcome to disagree with it, but you are not welcome to disobey federal law passed by Congress.
I have not disobeyed any federal law with respect to this.
Thank you, Mr. Assistant Secretary. I'm going to defer to my colleague, if I might, Senator Klobuchar.
Senator Klobuchar.
Thank you very much. Thank you, Mr. Chairman, and thank you for your service. Mr. Strickling. I'm sure it's been a long hearing, but I want to thank you for the work you do in a very complicated area. I've worked on this issue some as a member of the Commerce Committee, so I've been familiar with it for a while, and I know at first when people hear about this, it seems like, well, why can't our own government just control all of this? But I think we understand that this is an international internet, and one of the crucial aspects of the internet is that it's based on the open, free flow of information, and it's not run or controlled by any one government. NTIA's role was meant to be temporary as the multi-stakeholder process at ICANN was established. It has now been over a decade, and NTIA is simply working to transition its role. However, we do know that there are other governments across the world who want to control the internet or want to stop the spread of information on the internet to their citizens and limit the democratic values that it provides by allowing people to freely share in information across the world. Can you expand on, just stepping back a little from the minutia here, could you expand on why this transition is important to sending a clear message that the internet should be run by the multi-stakeholder process, quite a mouthful, by people from various governments and not by one individual government?
And that has been the long policy of Congress specifically as well. And back in 2012, both houses of Congress passed resolutions supporting the multi-stakeholder model.
What year was that?
Governance, 2012.
Okay.
And this Senate passed a resolution reaffirming its support for the multi-stakeholder model in 2015.
So in 2012, then, were the Republicans in control of the House when that happened? I think so.
I think they were.
Yes, they were, yes. Okay, continue on.
But the point is, support for the multi-stakeholder model has been bipartisan here in Congress. I mean, these were resolutions that were basically passed without objection. And so it's been important that we've served as a beacon to the rest of the world of the importance that civil society, businesses, technical experts play in charting the course of the internet, particularly the technical aspects of the internet reflected in the discussion we're having today about the IANA functions contract. And as I testified earlier, there's been a long struggle between those authoritarian governments that are threatened by their citizens being more actively engaged in managing internet resources, who have sought to bring internet governance under the authority of the United Nations or the International Telecommunication Union. That's what's at risk here.
So,
with this transition.
So what you're saying is what we've tried to do is set up a process so that it is the internet's governed by these multi-stakeholders instead of going over to the UN is where it would end up.
Absolutely. That has been the battle we've been fighting for more than 10 years.
And who wants it to go over to the UN?
I'm sorry?
Who wants it to go over to the UN?
Typically, it'll be authoritarian countries led by Russia, China, and other countries that are threatened by a free and open internet. They feel that if it can be brought into a framework where only governments can make decisions, that they'll be able to preserve their ability to censor within their own borders, as well as perhaps affect how it's...
And will the United States continue to be an important stakeholder under the ICANN establishment when that gets completed?
Absolutely. We will continue to participate actively.
And how will that be?
That'll be done through the Government Advisory Committee, but we in the State Department will also be advocates for internet freedom and internet governance issues in all international venues, not just ICANN.
Okay. At the Commerce Committee hearing on this topic back in May, I asked Ambassador Gross about the Accountability Working Group, and he testified that accountability is critically important. According to your testimony, NTIA has thoroughly reviewed and agreed with ICANN's report that ICANN has or will complete all necessary tasks called for by the transition proposal. What aspects of the accountability proposal give you confidence that ICANN will remain accountable after the transition?
Well, what the proposal has done is first, it's preserved largely the existing structure of ICANN, which is important for maintaining the stability of the Internet domain name system. But what it's done is it's now created a set of powers for the community to be able to exercise if the ICANN board takes an action that the community disagrees with. These powers include being able to reject a budget. They go to the point of being able to actually remove board members and spill the entire board if the board should totally go against the wishes of the community. And so while we hope and expect that those will never, ever be exercised, the fact that they are there serves as an important accountability control over how ICANN conducts itself going forward.
And one last question. Is the ranking member of the Antitrust Subcommittee focused on those issues? I know they were discussed earlier. My staff told me, and I understand that ICANN has, and will be treated as a private party. And like any private party, when it is compelled to act by the U.S. government, it is not liable under the antitrust law for those compelled actions. Beyond that argument of compulsion, ICANN can claim no immunity under antitrust law. Is that your understanding as well?
They have never had antitrust immunity, and they won't have it going forward.
How does the transition affect ICANN's ability to claim immunity under the antitrust laws?
It won't affect it one bit.
Thank you very much.
I thank both of the witnesses for your testimony. The first panel will now be excused, and we'll welcome the second panel to come and testify.
My name is Dawn Grove. I'm Corporate Counsel for Karsten Manufacturing Corporation. I also chair the Arizona Manufacturers Council, and I serve on the Board of Directors of the Arizona Chamber of Commerce and Industry, both of which oppose the current IANA transition. Karsten Manufacturing Corporation is the parent of Ping and Ping Registry. Ping is one of the top 3 golf equipment brands in the U.S. and provides over 800 jobs in Arizona. We are a closely held private family business started by my grandfather in his garage, and we've been passionately designing and manufacturing custom-fit premium golf equipment and other products in Arizona for over 57 years. We have vigilantly protected our brand and that name in many categories, including for domain name registry services. Our name is our lifeblood, and we aim to ensure that the Ping name reflects the innovation, design, service, and quality that we put into every one of our products. We believe rushing the transition through now in its current state will endanger manufacturers' rights to their trademarked brand names, severely disadvantage states' rights, jeopardize national security, and prevent the safeguarding of the internet freedoms we've come to depend on. Karsten, through its affiliated company, Ping Registry, paid ICANN's unilaterally set $185,000 application fee for .ping, and in our application, we informed ICANN of our well-known rights to our famous Ping marks. A wealthy ICANN insider based in India that had never made or sold a Ping product, had not trademarked the name throughout the world, filed a competing application with ICANN for .ping. We expected ICANN, with its actual knowledge of the India company's history of adverse domain name decisions against its affiliate and knowledge of our trademark rights and our global brand, to follow ICANN's own charter, bylaws, and applicant guidebook and disqualify the competing applicant. I believe Mr. Strickland also said that there were somehow equal applications. I find that stunning. We eventually discovered that due to ICANN's dependence on the sale of second-level domain names, which the Indian company would have sold more of since our registry is a closed .brand, ICANN had no incentive to follow its rules and bylaws, and ICANN's lawyers made it clear that ICANN would consider our application breached if we took them to court. Under duress, we ended up paying ICANN's $1.5 million at auction to keep our name. I cannot begin to tell you how scary it was for my family to go into that auction knowing that we might lose our name after 57 years, 56. Our experience is not unique. And I'm sure you're familiar with the many independent review complaints filed against ICANN and with the abuses of ICANN's trademark clearinghouse with the .sucks registry. The handoff is definitely more than a technical matter or a spreadsheet. ICANN is currently accountable to NTIA for both policy and technical functions, and we heard Secretary Strickland say that today about the policy that they make. Following the transition to global stakeholders, ICANN will be a standalone monopoly accountable only to its stakeholders, including 162 foreign government members and 35 observers, the Governmental Advisory Committee, or GAC. And under proposed accountability reforms, GAC consensus advice must be taken unless overridden by a supermajority of the ICANN board. This is a major change from the status quo, and it gives governments more power in ICANN going forward than it ever had before. Moreover, in the GAC, state governments are excluded from voting. States such as Texas, California, New York, whose GDP and populations dwarf that of many GAC members like Grenada, will have no voting right at the table. If the ICANN plan is so complete and so inclusive, where is the seat at the table for the 50 sovereign states? It also appears that both the NTIA and ICANN are operating under the assumption that a former federal contractor inherits the right to continue performing services absent a contract. If we applied that conclusion to various government services such as defense contracting, that would lead to chaos. The internet is no less important to our national security. The so-called empowered community, a convoluted structure of stakeholders that will only be activated in times of crisis, assuming they can all agree it is a crisis, is not suitable to provide day-to-day oversight of ICANN's board. The ICANN community requested, and the ICANN board rejected, a streamlined single-member model of governance that would have provided a method of governance for a method for day-to-day oversight by the community. It doesn't take much imagination to see how the stage will be set for an enhanced GAC to step into that role, since the community will not have that ability for that day-to-day oversight. In ICANN's rush to meet NTIA's deadline, some of the most important work was left undone. Workstream 2 issues, such as the permanent jurisdiction of ICANN and the protection of human rights like free speech, they don't get addressed until after the transition. Make no mistake, there are participants involved in the Workstream 2 work who desire to see ICANN leave California and be reconstituted in another jurisdiction outside of the easy reach of U.S. courts, and who would likewise wish to cherry-pick which human rights are observed by ICANN and which are not. My hope is that ICANN will intervene to safeguard the free and open internet for the use of the world, and also require the repairing of ICANN's structure to ensure that it adequately safeguards trademark rights, states' rights, human rights such as free speech and the free exercise of religion, our national security, and the security of our friends and allies around the world. Thank you.
Mr. Horton.
Mr. Chairman, Ranking Member Coons, my name is John Horton. I'm the CEO of LegitScript. My company's mission relates to consumer protection against cybercrime, particularly in the healthcare space. Today, ICANN argues that it is sufficiently accountable and transparent to take over stewardship of the internet. My testimony argues that it is not. Some proponents of the IANA transition would have this committee believe that ICANN is merely a technical organization. That is false. One of ICANN's most important jobs is to accredit domain name registrars and make sure that they comply with their accreditation agreement. The accreditation agreement says registrars are supposed to investigate and respond appropriately when they get a complaint that a domain name is being used for illegal or abusive purposes like spam, child pornography, or the sale of fake drugs. If the registrar doesn't, ICANN is supposed to hold the registrar accountable. I'm going to give a couple of examples why ICANN compliance is a failed system, but let me first explain why this is important. First and most obviously, this is a consumer protection issue. The victims of illegal or fraudulent schemes are typically internet users, often vulnerable populations. The second reason, however, is that in any sector, the payment processing world, search engine advertising, or registrars, you need some sort of system for voluntarily addressing and preventing abusive activity. If that abuse system does not work, is corrupt, or is not transparent, you leave the organization or sector vulnerable to governments looking for an excuse to step in and exercise more control over that failed system under the guise of fixing the problem. Third, it's imperative that voluntary abuse policies only address harmful activity like child pornography, fake drugs or spam, etc., and not free speech. That's why, before ICANN becomes totally independent, it's imperative that it demonstrate a compliance system that is accountable and transparent. Unfortunately, ICANN fails that test. One systemic problem is ICANN compliance's regular dismissal of complaints against registrars who ignore the contractual requirement to investigate and respond appropriately to abuse complaints. In some cases, the registrar clearly indicates that no matter how compelling the evidence of consumer harm, they won't do anything. Not only does ICANN close these complaints, but when asked what the registrar did to meet the contractual requirement, despite all evidence indicating that it did nothing, ICANN says that is privileged information between it and the registrar. This is like Kafka in reverse. Registrars are first afforded a secret informal compliance process, after which ICANN's reasons for dismissing the complaint are never disclosed. Because one of ICANN's most important roles is not transparent, nobody, including the multi-stakeholder community, can possibly hold ICANN accountable in the future. A similar problem is ICANN's accreditation of registrars that function as an arm of a criminal enterprise. The problem with this is giving criminals the ability to simply register their own domain names is like giving them a press to print their own money. RX Limited was a criminal network that sold addictive medications to U.S. residents without a prescription for years, causing a number of deaths. This criminal enterprise obtained its own ICANN accreditation, the only purpose of which was to generate rogue internet pharmacy domain names. The revenue from the registrar's illicit pharmaceutical sales was flipped into the trafficking of methamphetamine from North Korea, smuggling weapons in and to Africa, and diverting U.S. technology, reportedly missile guidance systems, to Iran. Although now de-accredited for unrelated reasons, what's critical to understand is that the individual in question almost certainly could not have funded those activities if his company had not maintained, for years, accreditation as a registrar from ICANN, despite it being obvious to many that the registrar was a shell for criminality. There remain other registrars today whose business model depends in material part on providing a safe haven for online crime. This is a problem for internet safety and for the future openness and independence of the internet. Anytime you have a failed system where voluntary compliance does not work and criminality and fraud are winked at, you hand governments the perfect excuse to try and exercise more control. Voluntary, effective, and transparent anti-abuse processes are imperative for any industry to remain independent, enabling them to tell governments, we don't need you to step in and fix our problems. We've got this. That is what we should all want for ICANN or any other organization entrusted with its functions. But ICANN accreditation and compliance systems are a mess. You don't buy your 16-year-old a car if they still back into your garage door every time they try to leave the house. Before approving a transition, the U.S. government has an obligation to internet users and the global community to ensure that ICANN's operations, including its compliance and accreditation functions, are accountable and transparent. To date, ICANN has failed this test. Thank you.
Thank you. Mr. Rosenweig.
Senator Cruz, Senator Coons, thank you very much for inviting me to appear today before the committee to discuss the IANA stewardship transition, and thank you particularly for your fortitude in such a lengthy panel and such a long hearing. It demonstrates your commitment to hearing something about the issue. For 2 years, I've worked on within ICANN on the proposed IANA transition alongside many of my co-panelists. Unlike them, I think that the effort for which I have the greatest admiration has produced a proposal that is not yet complete and is in many ways too flawed. In the written testimony I submitted, I spoke to 5 specific issues that I thought were important to discuss, but at the risk of going off script a bit, I wanted to directly address a question that you had asked earlier today, Senator Coons, which is whether or not there is a need for a testing period, which is something that I have advocated. In response to that, Assistant Secretary Strickling told you that there was no need because the technical aspects of this transition had been tested for 90 days and had worked perfectly. And that's absolutely true, but it's incomplete. The reason is that those technical transitions have been tied, as all the co-panelists here have said, to a reform of the accountability provisions that address how ICANN manages its policy. It is true that to some degree the DNS is just a technical system, but there is a host of policy that lies behind how that is operated. It includes things like how we address intellectual property claims, how we address human rights, how we allocate the domain names between competing applicants. It includes such things as whether or not the .islam, .gay, .amazon, .wine top-level domains will be delegated and to whom. Those are all controversies that have bubbled up in the last couple of years, and without saying whether or not they're resolved correctly, you can easily see that they are issues that trench not upon a technical question, but upon real issues of policy and governance that affect the globe all the way around. And it is those accountability measures that haven't been test-driven yet. Before the transition was announced, the accountability of ICANN, such as it was, depended upon essentially the U.S. government's exercise of soft power, the persuasion behind the scenes, if you will, plus the specter of a change in the contractual relationship. So it wasn't an explicit control, and Secretary Strickling is right about that. But nonetheless, it was implicit in many ways. That's what's going away, that soft power control. And what is coming in instead is a set of accountability measures that will lead to an empowered community that has the ability to essentially, as Mr. Del Bianco said, fire the board, etc. That hasn't been tested. And in suggesting that the need for testing arises, I'm not flying alone out there. That's exactly what the ICANN board suggested earlier when the community suggested the sole membership model. They said that if that was the model to be presented and the path forward, it may be prudent to delay the transition until the sole membership model is in place and ICANN has demonstrated its experience operating the model and ensuring that the model works in a stable manner. And it said that that was necessary because the new model would upset the balance of power and influence amongst any of the groups within ICANN, which can change based upon their willingness and ability to participate in the sole member model. Everything that the board said about that sole member model is true as well of the empowered community model. Indeed, I would submit, and this is my opinion, not a certitude, but I would submit that the empowered community model is more complex, more rococo, and less well-grounded in the simplicity of California nonprofit law than the empowered community model. And so when I suggest that there's a need for a test drive, it is not of the technical system, but of whether or not the empowered community model works. This would not be an indefinite postponement. Indeed, it is unlikely to last much longer than the time it takes to finish the Workstream 2 proposals, since many of those proposals will result in new bylaws provisions that would have to go through the new empowered community system. We'll have a chance to see if it works. I, like Mr. Zorka at the other end, I favor this transition. I think it is essential. Indeed, I think it's essential for many of the reasons that you addressed with Secretary Strickling earlier. I just don't think that we know whether or not this one will work yet. As it's drafted now, the accountability side of this is a leap in the dark. It's a triumph of hope over experience, if you will, and it isn't yet finalized in a way that gives me the confidence to be sure it will work. Mr. Del Bianco has gone through a number of stress tests. Those are immensely useful intellectual exercises in which we hypothesize how the system might break down. But all the hypothesis in the world is not worth a single minute of actual experience. For those reasons, my suggestion is a trial period, allowing ICANN to operate under the new model completely for whatever period of time is necessary to demonstrate the utility, and then if completion, an irrevocable completion of the transition thereafter, if the system proves itself capable of working. That's what I have suggested to you and to ICANN. It hasn't won the day thus far. Thank you very much for allowing me to testify today.
Thank you very much. Let me start by just making an observation for those government employees who are concerned about whether the conduct they're being asked to carry out is consistent with federal law. Mr. Strickling pointed to language in a committee report that he said gave them the authorization to do so. As I noted in that questioning, a committee report cannot supersede language passed into law. But what Mr. Strickling did not tell you is that committee report was a committee report for legislation that itself did not pass into law. And whatever authority a committee report might have for legislation that has actually passed Congress and been signed into law, a committee report that legislation that did not pass Congress has precisely zero legal effect and provides no safe harbor whatsoever to defying the legislative language that Congress has passed. Now, Mr. Zoka, I understand that just yesterday you and Mr. Rosenweig received a hostile letter from VeriSign's general counsel regarding the white paper that you both authored along with the Heritage Foundation expressing concerns with the transition. Without objection, I'd like to include that letter in this record. The VeriSign letter strongly suggests that if you do not remove references to VeriSign in your white paper, which the company disagrees with, the company may take additional action. I will note that it is highly concerning that VeriSign would send a letter of this nature to witnesses of this Oversight Committee the day before they are scheduled to give testimony. Such a letter could only be designed to have a chilling effect on witness participation and to disrupt the oversight functions of this subcommittee, which is seeking immediate answers to time-sensitive questions on an issue that has the full attention of the entire United States Congress. I would also note that it is more than a little ironic that VeriSign, which has a direct working relationship with ICANN and the United States Department of Congress, would seek to stifle individual speech in this way, which just so happens to be the main focus of today's hearing. This letter, unfortunately, perhaps provides a glimpse into how VeriSign and ICANN can be expected to conduct themselves post-transition without government authority over them. Given the allegations against you, would you like to offer any rebuttal or response to VeriSign's letter?
Well, we did issue a very brief public comment. I will say first, I've been in the think tank world for going on 9 years, and I've never received any kind of letter like that. It was not simply a correction, and we did note that there were perhaps slightly confusing word choices in our paper, and we're happy to correct those. It was, as you say, a threat. And the issue that we were getting at was simply to illustrate that actually we tend to agree that ICANN probably is not immune from antitrust suit, and that the transition probably won't change that. Our point really was to say there are still unanswered questions about antitrust law. And the purpose of the paragraph that VeriSign objected to was simply to illustrate what such suits might look like, and suggest that ICANN is inherently tied up in very controversial auctions at which there are lots of money at stake, and ICANN has a direct financial interest. And we were simply explaining that it would be unreasonable to expect that plaintiffs would not bring this kind of suit, and that antitrust litigation, whether frivolous or meritorious, will be used to attack ICANN and to discredit it by those that would indeed prefer to push to the ITU model.
Would you say that threatening witnesses before a Senate oversight hearing is consistent with an entity that we are being told we should trust to respect and protect free speech?
No, sir, although I would just remind everyone this was VeriSign and not ICANN. And again, I'm not accusing anybody of anything. We were simply trying to explain that there are many unanswered questions. The administration says it has zero correspondence about antitrust issues, yet you heard Secretary Strickland today say that there was indeed some consideration. That didn't turn up in the FOIA request that Americans for Limited Government issued. And again, the point of our paper is simply there are many unanswered questions that would have been resolved in a better process, where the NTIA had taken public comment and had issued a full report the way that administrative agencies are supposed to do, instead of simply rubber stamping what ICANN proposed.
And today, if ICANN tried to implement a policy that threatened internet freedom, could the United States simply refuse to renew its contract?
Well, yes, sir, and that is ultimately, when I say that I support a partial transition, that's what I'm getting at. I'm distinguishing between the right of the United States government currently to interfere in the editing of the root zone file, which I agree ought to be ended. That's a partial transition. That is different from what you ask about, which is the ability to put the contract out for rebid. That is something NTIA has threatened to do in the past. It nearly did so in 2012, and it has used that, as Paul says, as soft leverage to discipline ICANN. That ultimately is the guarantor of this whole system. And I just think we should be very careful before removing that bit of leverage. That decision is an irreversible one that NTIA has already set in motion, contrary to what Mr. Strickling told you about not violating the appropriations rider.
And that's a check that goes away if the transition proceeds as the administration intends.
Yes, Senator.
Following up on that point, Mr. Horton, in your written testimony, you said ICANN exercises these powers as a global monopoly. By virtues of its powers to determine who can sell domain names online and whether they comply with standards set out in the accreditation contract, ICANN has a significant effect on the future of the Internet. And it is seeking additional powers that would further limit the openness of the Internet. A working group hand-selected by ICANN's then CEO has proposed a shift to put all of the world's information about who is registered domain name behind a single gated wall and give ICANN or its contractor the sole power to determine who is authorized to see that data and for what reason, and to audit and impose penalties against Internet users who access the data for reasons that ICANN considers improper.
That's correct, Mr. Chairman.
Now, we're told that in place of the government oversight, we should trust the international stakeholders. And I would note, Mr. Del Bianco, in your written testimony, Secretary Strickland said we should feel comfort that the Government Advisory Council requires unanimity. And yet your written testimony said, quote, several governments have had voiced dissatisfaction with the present consensus rule for GAC decisions, so it is entirely possible the Government Advisory Committee could change its method of approving advice such that a majority could prevail over a significant minority of governments. Is that correct?
Yes, it is, and that's precisely what Stress Test 18 asked. I was the first one to raise this by saying the Government Advisory Committee could change its decision-making method, but the ICANN bylaws were written in such a way that they would still have to give deference to that advice. So therein lies the fix that the stress test led to. We have changed the bylaws, Mr. Chairman, such that the governments can use any rule they want to make decisions. But the only method of decision that our board at ICANN has to give deference and respect to is decisions reached through unanimity. And the governments resisted for 2 years on this one because they did not want to have to lock themselves into a situation where the U.S. government could, with one vote, veto what a handful or a majority of other governments wanted to do. Those are the kind of fixes that we did specifically in response to that stress test.
But the bylaws could still change.
Yeah, Mr. Chairman, the discussion of whether and how the bylaws change is true of any organization who lays down bylaws and articles of incorporation. Any articles of incorporation always include a clause that says that these articles and bylaws can be changed with a majority. But we have gone far beyond the typical assurances of a CEO, former or current. We changed the bylaws. It says it shall be in California. And if the ICANN tries to change those bylaws, it requires the approval of the community. The community can block that. The articles of incorporation indicate it has to be a California corporation. If ICANN tried to change that, it would require the consent of the entire community before they could make that change. So we have built in as many protections as we possibly can to guarantee they'll be subject to U.S. law and situated in California.
You are correct that most, if not all, private organizations have the ability to change their bylaws. That's one of the reasons why we are not typically in the practice of handing over monopolies over vital infrastructure to private organizations, because that is too much unchecked power to trust, particularly a private organization that the head of ICANN testified here. ICANN is not bound by the First Amendment. One of the great services that the United States of America provides to the world is following First Amendment principles to prevent censorship. The alternative, and Mr. Rosenwag, I want to turn to you on this. Your written testimony said, "It is my view that it is indisputable that under the current proposal, governments, foreign governments, would significantly increase their power in ICANN versus the status quo. The GAC, the Government Advisory Committee, has a power that other advisory bodies do not, an ability to convey advice to the board that the board must implement unless opposed by a majority vote. Would you elaborate on that, Mr. Rosenweig?
Yes, Senator. Before the transition occurred, the GAC was capable of providing advice to the board, that the board was bound by its procedures to seek to negotiate with them if it disagreed with that. Under the GAC's internal operating procedures at the time, that advice would have had to have been by consensus, and the board would have had to would have been capable of rejecting that advice simply by a 50% plus one vote of the board. In practice, the board tended to seek a supermajority, but the board statutory requirement was simply 50% plus one. The bylaws with respect to that advice made two changes. One that enhanced GAC power by increasing the threshold for which it would be rejected, and the other by institutionalizing the consensus requirement, so maintaining the status quo. So in effect, from where we were before to where we are now, the threshold for rejection has gone up. In addition, and to my mind much more significantly, the GAC has been invited to participate as a voting member in the empowered community. That empowered community will have, as Mr. Strickling and all the others have said, significant oversight of the board. Indeed, that is the very methodology by which we anticipate the multi-stakeholder model for controlling ICANN board and staff activity. As of right now, the GAC has not determined whether or not to seek that position, and Mr. Strickling spoke to that as well. But in the event it does, it may very well seek to do so by majority vote, not by consensus vote. Its current internal operating procedures would suggest consensus is required for that as well, but those procedures are subject to majority rule change within the GAC. So we have gone from a place in which the board by 50% plus one could reject GAC advice, and the board had no formal say in oversight of the board, to a position in which there's a higher threshold, and the GAC has been invited to sit as a voting member. I suggested 2 years ago that one of the key tests for the suitability of this is that governments remain in a purely advisory role, and the transition changes that. It remains to be seen whether or not that will have significant pernicious effects or only partially pernicious effects. Again, a reason why I suggest at least a trial period is necessary.
And I want to make sure it is absolutely clear to this committee and to the American people. Your testimony is that if the Obama administration's proposed transition goes forward, that it is indisputable that it will give foreign governments more influence and power, including Russia, China, and Iran, and other regimes hostile to free speech on the internet.
I think the only government that loses power in this transition is the United States government. All the others gain power.
And why possibly would it be in the interest of the United States to put forward a proposal that weakens the authority of the United States and that strengthens the authority of Russia and China and Iran?
I'm not in a position to answer that question on behalf of the United States government, sir.
Well, hopefully the United States Congress is in a position to answer that. Now, one answer that we have been given by some witnesses is we should rest comfort that ICANN, once unaccountable to the United States government, once lacking any supervision, we can still be confident will remain domiciled in the United States and California. And yet, Mr. Rosenweig, in reading your testimony, you also wrote, quote, "The idea that ICANN would pack up and move has been contemplated by ICANN's leadership." And specifically, you focus on the testimony that we discussed earlier in this hearing of Mr. Shahade discussing a, quote, "parallel legal international structure maybe in Switzerland for ICANN." And in Senator Coons' exchange with Mr. Strickling, it was suggested, well, perhaps that referred to something completely separate and independent and not ICANN itself. And yet your written testimony suggests that interpretation is incorrect. Specifically, you said, In July, the French Senate published a lengthy report in French building on Shahadi's testimony, and the report proposed the, quote, Swiss model that would, instead of transforming Internet governance to a one-country, one-vote system like the ITU, have ICANN assume international legal personality as a, quote, world ICANN on the model of the Red Cross. Is that correct?
That's my understanding of the French Senate report, which I also understand to have been in reaction to Mr. Shahadi's testimony. I do not know if that translation from Mr. Shahadi to the French Senate was accurate, but it certainly is their interpretation of what he was saying.
And one final question. Your testimony also gets into the .mil and .gov top-level domain names. And it is that there is no concrete assurance beyond an exchange of correspondence that .gov and .mil will remain under the control of the United States government. Right now, for consumers, that is an essential consumer protection. If you go to senate.gov to see official government records, you have some degree of confidence that that is not an illegal scammer. If you go to irs.gov, you have some degree of confidence that this is not a phishing scam designed to perpetuate identity theft. Under this transition, there's no assurance .gov and .mil remain with the United States government. Is that correct, Mr. Rosenweiss?
There's no assurance beyond the letters that have been exchanged, which, as I understand, are not enforceable contracts. To the extent that you think that the letters are themselves an assurance, then they stand in that stead. But I am puzzled by the argument that entering into a contract about these is somehow a derogation of sovereignty. I had not heard that until Assistant Secretary Strickling said that earlier today, and so I hadn't had the chance to think about that. But the government enters into contracts about its intellectual property and other property all the time. So I want to see that analysis and think about that some more. I don't have that piece of answer for you.
Okay, thank you. Suggested, Ms. Grove?
Yes, please. Thank you so much, Senator Cruz. You referred to our experience as a bad experience, and I understand how it could be chalked up to that, but I think it's a lot deeper than that. There was actually a statement in the applicant guidebook that prevented ICANN from being able to give our name to the other applicant because they had a number of uniform dispute resolution policy decisions against it already. That should have prevented it right there. But ICANN didn't follow its own applicant guidebook, and we were very shocked to find there was no one to hold them accountable to do that. The only group that could hold them accountable was the NTIA, and they had decided to take a hands-off approach to it. So even though it is complicated, and even though people have spent a lot of time working on it, and we do have a person that's involved in the multi-stakeholder group on our behalf, you don't have to spend thousands of hours doing that or be a $800 an hour ICANN attorney or a computer guru to see that if you have to bring the whole world of multi-stakeholders together to hold ICANN to follow its own rules, it's going to be very challenging to hold them accountable at all.
Thank you, Mr. Chairman, for the opportunity to respond to that. As to the suggestion that I spend time getting involved in the ICANN process, I've already lost countless hours of my life doing that, talking about compliance and other issues. The problem is that ICANN does not follow what is already written and has already been developed by the multi-stakeholder community in the Registrar Accreditation Agreement. And as to why that happens, the problem is a fundamental one of transparency. When you try to get to the core of the problem, it's like a secret court. Now, part of the problem here is that the multi-stakeholder community is, the fact that it's open is a good thing, but anybody can be involved in what is a very complicated process, and it's hard for a lot of entities that have a stake in the future of the internet to be involved in these complicated and very bureaucratic groups without dedicating a full-time employee or employees to these processes. Some of the most motivated sectors are the registrar and the registry sectors, which have a lot of power in the multi-stakeholder community and do not want compliance to exercise the functions that are clearly written in the registrar accreditation agreement. So that's part of the problem.
Thank you, Mr. Horton, and I want to thank each of the witnesses on the panel. I will say we heard a lot of interesting expert testimony. I thank you for the time you put into writing your testimony, to coming here and answering these questions. In my judgment, the most powerful and most troubling testimony we heard today was that it was indisputable that this administration's transition, if it went forward, would increase the power of federal governments, of foreign governments, including Russia and China and Iran, and decrease the power of the United States of America, which is the only entity bound by and able to fight to vindicate the First Amendment. I'm reminded in the 1970s when President Jimmy Carter chose to give away the Panama Canal, which America had built, and I believe that undermined U.S. interest and U.S. sovereignty. And likewise today, the internet is working, and this is a solution in search of a problem that poses real risks to the liberties of Americans. And so it is my hope that Congress continues to exercise its Article I authority to protect free speech on the internet, to keep the internet free of the coercive authority of foreign governments that would love nothing more than to silence and censor free speech. I want to thank each of the witnesses again for coming and testifying, and we will keep the hearing record open for an additional 5 business days, which means that the record will be closed at the end of the business day on Wednesday, September 21st, 2016. This hearing is adjourned.